All right, moving right along with our venture into the Settled Land Act, or the Settled Land Acts that culminated into the Settled Land Act 1925. Holy mackerel! And in doing so, we're now going to find out where the true legal estate exists and where our true rights and warranty is as pertains to having the right to vest that legal estate. Now, I'm going to have to apologize right off the get-go. I don't know where this article came from, and I'm not able to. And I just did a quick. I'm sure that maybe you guys can help me out, and you can look for it, by just sort of using Google search and using certain sentences and seeing something pulls up. And I went to Canley. I couldn't find it, so I don't know where this came from. But it is, I think, one of the best short introductions into what the Settled Land Act is and how it came to fruition. And so what I'm going to do is just going to read from this. It's not my writing. And then I'm going to extract certain things from here. I've got little cue points that I've added so I can go to something to help deepen a better perspective of exactly what's been said. And as usual, I'm not going to be editing, so you're going to have to take all my brain farts and sometimes my inability to maybe pronounce something correctly at bay. Because obviously it's just about getting the information out. And then you guys, don't take my word for it, but look into it yourselves. And here we go. The object is to render land, this is about the Settled Land Act 1882. The object is to render land a marketable article, notwithstanding the settlement. Its main purpose is the welfare of the land itself and all interested therein, including the tenants, and not merely of the persons taking under the settlement. The Act of 1882 had a much wider scope than the Settled Estates Acts. The scheme adopted is to facilitate the striking off from the land of the fetters imposed by the settlement, and this is accomplished by conferring on tenants for life, in possession, and others considered to stand in a like relation to the land, large powers of dealing with the land by way of sale, exchange, lease, and otherwise, and by jealously guarding those powers from attempts to defeat them or to hamper their exercise. Okay, we're looking at the Settled Land Act 1925. We're going through the table of contents here. The whole idea of the act was to settle that land interest for the benefit of the tenant for life. And as I've already mentioned, you cannot be, or sorry, that's not the better way of saying it, the legal estate cannot even be realized in the marketplace unless it goes through a life, or the tenant for life. All the powers and duties, and that's what this act did, was to make sure that the tenant for life had all the powers and duties in order to sell or lease or whatever he wanted to do with that, with his land interest, inasmuch as not getting those in remainder and those who either have a beneficial interest involved. Therefore, that would impede in many cases the sale. So if someone came along and wanted to buy that life interest that was held by the tenant for life, well, the tenant for life, based on the old criteria, had to go through the beneficiaries and so forth, and who wanted what, and those in remainder, and it just, of course, created a huge hindrance, and it was costly as well, because you had to get the court involved to try to juggle this, and by that, sometime by that time, the person who wanted to purchase that legal title or that legal estate just simply lost interest, and plus these legal estates were huge as well, so the marketability of huge estates were only with those who had the money in which to do purchase them. Okay, as you see here, as we scroll down, it's tenants for life and persons with powers of tenant for life. And who is a tenant for life? Boy, come on, let's go here. It's a person. Let me get that centered for us here. It's a person. There we are. A person of full age who is for the time being beneficially entitled under settlement to possession of settled land for his life is for the purposes of this act the tenant for life, and that land and that tenant for life under the settlement. Okay? So, and we can go down to, further down here and read this, but you guys can do that on your own time and speak to it. But, again, look at section 4 here as well of 19. A person being a tenant for life within the foregoing definition shall be deemed to be such, notwithstanding that under the settlement or otherwise the settled land or his estate or interest therein is encumbered or charged in any manner or to any extent, and notwithstanding any assignment by operation of law or otherwise. And that's what we deal with, guys. Operation of law. This is all done by operation, not an act of parties. Another important point to drive home. If you're listening to the judge or anybody else and they're speaking about some sort of agreement, you already know that is not speaking to your interest. Your interest was moved from the moment you were born through an operation of law, not an act of parties. Why? Because you were an infant first, so there's no way you could have got involved in getting into contract or agreements or trust, okay? And we go on, of his estate or interest under the settlement, with whether before or after it came into possession, other than an insurance which extinguishes that estate or interest. Okay. Now, under the Settled Land Act, I also went to 106 because I wanted to show you how much power the tenant for life has, and that's what this whole act, like I said, was not only to create the settlement of that land for the interest of the land, but to give that interest fully and completely transferred over to the tenant for life. Okay. Now, this is very important for some of you who haven't read this. Section 106, prohibition or limitation against exercise of powers void, and provision against forfeiture. If in a settlement, will, assurance, or other instrument executed or made before or after, or partly before or partly after the commencement of this act, a provision is inserted, A, purporting or attempting by way of direction, declaration, or otherwise to forbid a tenant for life or statutory owner to exercise any power under this act, or his right to require the settled land to be vested in him, or attempting or tending or intending by a limitation, gift, or disposition over of settled land, or by a limitation, gift, or disposition of other real or any personal property, or by the imposition of any condition, or by forfeiture, or in any other manner whatever, to prohibit or prevent him from exercising, or to induce him to abstain from exercising, or to put him into a position inconsistent with his exercising any power under this act, or his right to require the settled land to be vested in him, that provision, as far as it purports or attempts or tends or is intended to have, or would or might have, the operation aforesaid shall be deemed to be void. That is an extremely powerful last bit of verbiage right there. When you put shall and void in one complete sentence, that means absolute. If you just put void in a sentence, that doesn't mean that it's absolutely void. There might be some sort of factors that come into play. This, when it says shall, it means absolutely. So there you go. Anyone that brings in any interest through through a beneficial use, and then they try to overreach your right as a tenant for life to that legal estate, means automatically that they speak. That's void. That's what's great when you hear when the lawyer, if the lawyer ever gets involved, it's like the Peanuts teacher, the character. Wah 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 wah. They cannot say anything because they have no power when we're speaking about settlement act. They're lawyers. They're dealing with those matters of beneficial use. And obviously those matters that are pertaining to perpetuity instruments like government and church and all those kind of things. This is your individual interest. That means when they speak, they can only speak to matters of fiction. So that's why I want to bring your attention to that point before we move on. Now, you may have caught when I was reading section 106, and it's saying purporting or attempting by way of direction, declaration, or otherwise to forbid a tenant for life or statutory owner. Well, who is this statutory owner? Now, I did attach one time the definitions, complete definitions. Well, they're not complete in as much as what we're interested in, and I've added a few things, and of course I'll attach that definition page to this video. And I'm going to go down to what I added to the definition page, because we wanted to find the statutory owner again to get some deeper knowledge. And I extracted this, I think it's from the freedictionary.com, the one that I always use. Statutory owner means the trustee of the settlement or other persons who, during a minority, which is, of course, as a time we're an infant, or at any other time when there is no tenant for life. Now, let's just stop right there. When you're an infant, you're nothing. You're not a tenant for life. You can't form contracts. You can't form allegiances. So, in essence, you're nothing. So, something's got to protect your legal estate. Because, again, the legal estate had to be created at birth in order for you to even be seen in English law, okay? But at this time, you're not even recognized. Someone's got to take care of you. That's what we have, guardians. But that's what happens as soon as you're born. Look at this, statutory owners is one who's during a minority or at any other time when there is no tenant for life have the powers of a tenant for life under this act. But does not, oh, I'm sorry, I know where I got this from. This is actually from the Settled Land Act 1925 itself under definitions. I think it's under section 117 definitions. And you'll see a bunch of definitions in there as well. So you can extract, in order to read this act better, the Settled Land Act, you can go to definitions. So that's where this came from, not the freedictionary.com, okay? But does not include the trustees of the settlement, where by virtue of an order of the court or otherwise the trustees have power to convey the settled land in the name of the tenant for life. And you see right now, since the tenant for life is not alive, there's no tenant for life when you're an infant, are there trustees at that time? Something to consider, something to debate, something we can talk about. I would say no, there are no trustees. That's when we have a statutory owner. All right, let's get back to the commentary. At the same time, the rights of persons claiming under the settlement are carefully preserved in the case of a sale by shifting the settlement from the land to the purchase money, which has to be paid into the court or into the hands of trustees. The Act of 1882 and the subsequent acts ought then to be construed by the court with regard to those broad principles and in spirit of wise and reasonable liberty. Think we need to go into much of that last little thing, except guess what happened? They went from the land and they had to change it over to purchase money. So that would be the capital money. Okay? Scroll up here a bit. Settled Land Act 1882. The purpose is to characterize land as a marketable item regardless of the settlement. Its main purpose is to derive an interest for the benefit of the land itself and of its tenants, and not solely from the conditions established from the consequence of capacity of the person who takes the land under the settlement. And remember, the tenure was based on the quality of the state, thereby it was based on tenure and status. So this is what they're saying. We don't want to take that into, we're not taking that matter of just saying status and the bloodlines, and this is you have an absolute or an absolute right because of it. It's saying that now we're going to look for the benefit of the land itself. Now, even though status is still important, but the status is important as an individual when we're coming as a settler, not the statuses that were enjoyed by the barons and lords and so forth, okay? Well, that's how I read it. Again, you guys can help me out in anything if you think that I'm way out in left field somewhere. Okay, In other words, it is just not land and then next the tenant that the rights to ownership and possession become ordained, but rather the introduction of a future interest. Okay, so let's go into what that means. And now we're going to get into what it states that the common law can only deal with, and what are those successive interests, to which at the very section 1 of the Settled Land Act speaks to. All right, back to the Settled Land Act, 1925. We better find out what constitutes a settlement. Section 1. Any deed, will, agreement for a settlement, or other agreement, act of Parliament, or other instrument, or any number of instruments, whether made or passed before or after, or partly before and partly after the commencement of this act, under by virtue of which instrument or instruments any land, after the commencement of this act, stands for the time being limited in trust. Sorry, I grabbed the wrong mouse. I got two mouses running here. Limited in trust for any persons by way of succession. All right. What does that mean? And I'm going to, I thought I had the book with me, so I'm going to have to pause and go get it. Okay, I'm going to bring our old friend here, Boer Alaskan Cases and Notes on Land Law. I know last time I did that, I couldn't see whether it was getting focused, and I see that after the point that I can't, my arms are not long enough for it to happen, so I'm just showing you that's what it is. We got chapter 8 and page 327 I'm going to read of. And it's called Common Law Future Interest. And here is best way, I think he describes it the best. He says the common law recognized the following types of future interest. 1. Reversionary interests, which include the reversion after a fee tail, after a life estate, and after a leasehold, or a term of years. Number 2, possibility of reverter, which is just essentially another point of reference, a different point of reversion. Number 3, right of entry for a condition broken. And number 4, remainders, vested and contingent. These interests emerge under the rules of common law. Conveyancing referred to in part on, and he goes and says he's referencing his other pages 37 to 39. And maybe we'll read some of those because again it sets the foundation. But there you go, those are successive interest. Now you might be reminded of this page if you saw my previous video speaking, I think it was talking about the black belt barrister. But anyways, this page here is discussing, this is the Canadian property law, real property, and remainder rules. And it's from Wikibooks. And it's going through here that an estate in English medieval legal parlance was an amount of time over which one held property rights. There are 3 types of estates: fee simple, fee tail, and life estate. Now before I'm going to get into that, because of the response I received from, well actually it was Mark from Peacekeepers, he's going, oh, in one voice or at one time you're saying that the tenures have been abolished, and then next you bring them back in, so you know you don't know what you're talking about. Well, he obviously doesn't know what he's talking about because he didn't read the act to find out what was abolished through that. So let's get right to that first. The Tenures Abolition Act 1660, and the act is for an act taking away the court of wards and liveries and tenures in captive and by knight service and purveyance, and for settling revenue upon his majesty in lieu thereof. The reasons for passing this act. Whereas it has been found by former experience that the courts of wards and liveries and tenures by knights service either of the king or others, or by knight service in captive or soccage in captive of the king, and the consequence upon the same have been much more burthensome, grievous, and prejudicial to the kingdom than they have been beneficial to the king. And whereas since the intermission of the said court, which had been from the lower and 12th day of February which was in the year of our Lord 1645, many persons have by will and otherwise make disposal of their lands held by knight service, whereupon, okay, this whole thing is the removal of the tenure in fee, not fee simple or life estate or the entail interest. It's the fee. That's what attached the very beginnings and origins of the feudal land tenure system, where again, I've discussed, there is no way you could not, that you would be able to, in a course under English law and directly with the king, unless you were a tenant first. Now there was tenants in chief, which would be the barons, or tenants in captive, would be lands, I believe, held immediately of the king, not immediately, so those lords. And they're not tenants in the traditional sense that we understand tenants that involved under them. Because they're not using the land for beneficial interest, they're sort of the managers, okay? And as managers for that larger estate, they also had to provide a service. This was a removal of the service agreement, which then moved into the free and common stockage. Now we'll get into that point. As it reads here, there's the fee simple, which is the most prevalent type of common law estate, and as we talked about before in Born Laskin, saying that's the largest and the largest estate you could ever hold in English common law. And then we have the life estate. That's what we're interested in, because that's the estate that had to be created in the beginning. And you're going to find something really interesting here, because I connected a couple dots here that were I saw, and it sort of clicked again with me that, wow, there's your proof that it has to come through a life estate. I'm going to get into that right away. And pretty much is saying that the other main type of estate is a life estate. Very simply, this means that someone holds the rights to the land for the duration of his life. And that is called now the quantity of estate. Before it was quality, which was the tenure and status. Now it's quantity. That's what it moved into, and that's how we got into our future. Because we went into these types of estates, we were able to see, the common law was the first time able to look at future interest, so successive interest, which we already went through, you know, the reversion, reverter, and that type of thing, okay? And then the fee tail. Fee tail is the bloodline, so it'd be to A and his heirs, okay? And that is the one who has possession. That's the fee tail in common law, not the fee tail of the beneficial, because again, you can have two types of interest. That fee tail is governed by the laws of inheritance under the common law only. If you're talking about an inheritance of a fee tail of a tenant that has a beneficial use, of course, as we know, it's a different, completely separate, different interest. The other type of estate, as we went through succession, is limited in trust for any person in possession. Okay, and it goes through the different types of possession you can have under the agreement. Now, from this point, we can now look at an overview of what estate you can have in common law. As we already stated, we have the rules are the successive interest or those in possession. That's the only two means in which you can hold a legal estate under the Settled Land Act. And it states here, in law, estates can be in possession or expectancy. And there are two types of expectancies: remainders, created by the parties, and reversions, created by law. Possession estates, where a present interest passes to and resides in the tenant, do not depend on any subsequent circumstances or contingency. Reversion is specific property held by a prior owner in property given to another, which, upon the happening of some future event, will return to the prior owner. A reversion arises by operation of law on every grant of an estate where the whole interest is not parted with, whereas a remainder is created by express words. So now that we see that we, again, is reversion because it's through an operation of law, and we hold the legal estate, therefore we hold we will always hold that title in order for any other lesser estates to be created therefrom. Now, just to finish up with this, see again, we're going to go back, we're going to drive this home. A reversion is a special instance of a remainder, distinguishes it in two important respects. Reversion is a special instance of a remainder. A reversion arises by operation of law on every grant of an estate where the whole interest is not parted with, whereas a remainder is created by express word. Therefore, if we're speaking remainder, we're speaking an act of parties, obviously not the interest we are concerning ourselves with. And even when we're speaking about the Cestui Act of 1707, which is a remedy for the beneficial interest, that you see it spoke of those two types of future interest. But again, we're always only reliant on, and ever will we ever be interested in, is the reversion. Now, if you remember, I said it has to pass through a life estate. A reversion begins, or a legal estate has to go through a life, and that's where the reversion then is annexed to through an operation of law. But here, this will help, drive that matter home. And this is in that same article, or that same wiki books, the Canadian Property Law, Real Property, okay? And it's got remainder rules. Now just look at the rules that remainder has to follow under. A remainder is a right in land after a life tenure or other guaranteed tenancy has expired. After. Okay? But here's another great point. No remainders after a grant in fee simple. So if we scroll up, remember the three types of estates that are available in the common law are the fee simple, the life estate, and fee tail. So obviously, you could not create a fee simple at birth. Why? Because there'll be no remainder. That's it. The entire estate is done. So there's your proof right there. There is that in order for even a remainder to exist in law, it has to be done through a life estate. That then creates the whole concept, as we just read, either have possession or expectancy. And of expectancy, it's either reversion or remainder. And reversion and remainder all come through the life estate. Back with the article. So we'll start back up here. In other words, it is just not land, and then next the tenant, that the rights to ownership and possession become ordained, but rather the introduction of a future interest that will meld together the person and land into one mutualistic marketable benefit that then becomes the value of purchase. There it is. Bang. Boom. Did you see all the lights come off? Or the lights come on? Lights come off. Yeah. That's the new agreement. To see what happens, it is not that they're melded together, not the beneficial interest or anything else. It is, I'm always stating that a new agreement is made, and then from then a new agreement, laws and rules are then are created thereunder. So it's a new agreement that as soon as you change something and then bring everybody under that new change, which happened in 1925 under Law of Property Act, whereby everybody came in under trust for sale, that became the mitigating factor, or became the administrative rule, to which then all interests, which were two, that would be the fee simple absolute to that interest, which is a beneficial interest, and the leasehold. Those are the only two things you can see under law and property, which are traded subject to a trust for sale scheme. As we continue, the Settled Land Act 1882 expanded the vastness of the previous limitations. Now, when I say limitations, we have to keep that in mind, that limitation just means the confinement that is involved within that act. It doesn't mean limitation all-encompassing. It just means within the Act, here are the certain limitations. Just like Settled Land Act, it has certain limitations, like a fee simple, like a life estate, like an entail. Those are limitations. That's what common law is strict. It is within whatever you're holding, it means that and that only, and it's subject to the common law rules. Okay? Conferred in the Settlement Estates, conferred in the Settled Estates Act. It served to dissolve some of the restrictions imposed under the settlement, which focus on just the land itself, through the advent of conferring additional powers upon the tenant for life. And there it is. Again, it is the tenant for life that the Settled Land Act is dealing with, inasmuch as to make sure that the tenant was given all those powers in order to deal with that. To the sale, exchange, lease, or otherwise of the rights to land by removing the suspicion that these new rights could be defeated or hampered in their execution in any way. Now, if I just went back to, just for our interest, if I still have it up here, let's go section 106. Remember, as far as imports or attempts or tends or is intended to have or would or might have, the operation aforesaid shall be void. That's what it's speaking to. So, we turn back here. So, if anything tries to overpower the tenant for life, that's why it gave so much power to the tenant for life, then it is void by the very mention of it. Okay, the tenant for life has all the power to which you are or have to be in order to be a settler, a beneficiary, a citizen. It doesn't matter. You have to be a tenant for life. That's how everything begins. All right. This symbiosis relationship established a will of a person as being the sole benefit of the land and himself, thereby forming the beneficial interest that would give rise to the reasons to form a trust, so as to protect its subsequent value through the laws formed around this new agreement. And there it is again. The beneficial interest, now a right. So now we're talking about the beneficial interest. Okay, the common law interest, we already know what that is. We're talking about the beneficial interest that could be annexed to the legal estate, but separate. How? Through a trust. Now a right protected under the settlement is the marketable item spoke of at the beginning of this commentary. So that is what's for sale that everyone's purchasing, that beneficial interest, not the common law. Okay, we're never dealing, no one's ever dealing in the common law interest, especially government. Government has no rights to that interest. Okay, they have the rights to deal with the beneficial interest derived therefrom. And whereby this interest now becomes a value exchange for purchase money, and so can be paid through the courts or placed in the hands of trustees. See, who do we have to go to deal with our accounts? The courts. This action thereby preserves the rights of the person, as this is now the subject matter. Don't always talk about status and subject matter create jurisdiction. See how we move into different jurisdiction because it's a different subject matter because we're dealing with a beneficial interest. Being considered and then exchanged in contrast to just the land under the settlement. As such, these new interests is the subject matter that the executive serves to administrate and also affords the judicial with the powers under the laws of equity over the estates of the former common law. Man, that's so beautiful how that reads, because now you're really getting what I've been speaking about. Okay? That you become executor. When people go, well, I'm the executor of this estate, and then they're thinking they're dealing with a common law. Well, no, they're dealing with a common law as it's the common law that's annexed to the beneficial interest, to which then if you have a issue and you're the Cestui key trust, the beneficiary, directly dealing with the trustees, which you can do that. I wouldn't suggest it in the long run, but I'm not going to talk about that right now. But The fact is, if you have any issues, you're the one who's holding that new subject matter, that new interest. Thereby, you become the executor if you have an issue with who? The trustees. Okay, because the trustees are holding the legal estate as the principal, as the res that stays there, that's consistent, to which you're driving profits there from the use of that land interest through government and so forth, that then has to pay for the rent according for the waste that it creates, that to which then those profits are given to the beneficiary who receives the beneficial interest. So you become the executor, not settler of the original trust. You become the executor of that beneficial interest if you find that the trustee is not managing those profits, not the legal estate, because you don't have any right to the legal estate. Get your head out of that. If you want to become the beneficiary, that's when everybody's going, what is legal estate? Where's it coming from? Dude, you don't even know where legal estate is because you're never dealing in common law. You're dealing in the common law of the beneficial interest, which is a different subject matter. And then you come as an executor and saying that you have a common law right, but that common law right exists where? Well, it says right there, doesn't it? Under the laws of equity. And that then prevails if there's a conflict between the common law, which is the strict laws that then rule over that beneficial interest, versus the laws of equity, because then equity is that develops the story. Okay, develops the story. It doesn't look just right to the agreement. It develops the story of what's really going on, and that's the entire court process we're dealing with today. It's just people telling their stories, and then the judge acts as sole chancellor in this whole thing and executes a determination based on what he hears. But if you're just speaking to a point of law, then he's going to what is agreement. What's agreement? It says this is black and white. See, there's no argument. See, that's the beauty when you get into when we're speaking to the common law. It's black and white. There's no obscurity. It is absolute. So that's all we're ever speaking to. Thereby, we don't need to speak to what he said, she said, and all that, because that's an equitable thing. That's conscious. And here's another thing that came to my mind when these people, and we used to speak, I used to do it, and I said it before, where we were speaking to matters and saying, I'm a live human, you got to hear, and they're not hearing me, I'm a live human. And then you got to prove, we did affidavit of life and that sort of thing, got to prove I'm alive and I'm not dead at sea. Which I've already went through in a couple of, when I was discussing the Cestui Act of 1666 that the sovereign freeman movement like to use. And that is, in order for equity to even be considered, to which all the courts are that are dealing with any interest that people hold under government and such, and under Parliament, under the Lord's temporal and spiritual and such, is a matter of equity. And equity is conscious. And in order to have conscience, you have to be alive. See now look at the ridiculousness, the craziness that we then institute by trying to show that the courts that we're alive and are not listening to us. Well, they're not listening to us because they already know you're alive, but that's not the issue. They're speaking to either the agreement in its entirety, therefore it's black and white, based on that common law interest of a beneficial right, or they're speaking to a matter that developed from the agreement, that is, the agreement itself cannot provide remedy. Okay, so in equity, you have to be conscious. And in order to be conscious, obviously, you got to be alive. Okay? Therefore, the Act of 1882 and its final compilation, formed in 1925, should be the basis of consideration, since it was initially through the settlement of the subject matter of common law states, where they settled Land Act 1925, right? That give liberty to the subject matter now conveyed as a beneficial interest. Boom! Again! Where's my mic? I gotta drop it. Okay? Remember, again, with the peacekeepers, even though why even waste my time anymore, is they're saying, everybody likes to use that word, and not only them, and I shouldn't just pick on them, but most of the Freeman sovereign movement, where there's a conflict between law and equity prevails. Well, there it is right there. It just explained the two that it's the common law states that give liberty, even the idea of the subject matter for the beneficial interest to be used. How can it even overreach? It's like saying the exact same thing as saying, you know, I'm a tenant, I'm renting property, and at any one time, if I have an argument with the landlord, I can overtake his legal title ownership of the land as a tenant. Well, that's insane, obviously, for the very fact that obviously the tenant, the renter, cannot ever have rights to the legal interest of the landlord. Again, to drive this home, to stand in your own, stand in your full power, you've got to realize those two different interests. Goes on to say, the land is still separate from the person. This is all pervasive, never ending, and only serving to act as one complete unit of measure, person and land, when it has been agreed upon to the purchase of this beneficial interest. So there we go. It is for greater certainty that this merger is dealing more or less with the person first, okay? It is, but the person's right to land. So we're dealing of a beneficial interest where the beneficiary is saying that, hey, you're doing something wrong with my profits, okay? Whereas a common law is dealt with the land interest, okay? And that's where the obligation arises from, whereby if you're holding anything under common law, means that you are holding a land interest that has been filtered through different types of subject matter that then create the obligation by the very fact you are holding a birth certificate, you're using that as identification, you're purchasing under trust for sale, and you're purchasing property. Proves you have an obligation. And for anyone to say after the whole fact that, oh, prove your obligation, as I've already said, and you guys can say now, moving on forward to anybody in the sovereign free man movement, and you listen to anybody now with New Year's, you'll see the mistake in all cases. They're fighting within the system and giving the power to the system. At the same time, where's my obligation? And prove that you have any rights over me, as they're holding everything that proves the obligation. Please like, subscribe, share. Hey, any donations greatly appreciated. And I hope you enjoyed this video. In one take, again. And yeah, there's other areas I love to edit now, listening, going back on some of my videos and saying, what? I didn't even say it right, or I, tripping over my words and such. But the reality is, I'm the only one who's bringing this it appears anyway, bringing this to the forefront. So you're stuck with me in this whole thing. But at the same time, you have something that I never had at the beginning, and you've never had at the beginning as you're reading this. The basis and the foundations of what law, and I stand on the shoulder of a giant. This man, I'm telling you, without him, and secondarily, my openness to say, you know what, let's just listen to what he's got to say instead of trying to get stuck in the old equity trap and and it's all flowery and it's, again, it's like jumping around and flowing around and dancing around in a field of daisies just because it sounds so nice. That everybody uses it and we don't understand what law is, that give equity its power or its reasoning. Now you have the full basis. You can, like I said, there is no judge. You want to learn to judge, that's what I'm talking about. Why? Because you want somebody that even comprehends what law is, and I'll guarantee most of them do, but they can never speak about it because that's not what the subject matter that you bring into the court in the first place. How can they speak about something that's not even brought on the table? It's like sitting down and for a bowl of cereal and going, where's my, and that's what's being served, and then start whining, complaining about, pancakes and, your syrup and everything else. We're dealing with the issue and only the issue and the subject matter, and driving that home. Subject matter creates jurisdiction along with status, and every new agreement creates a different interest. But we have them divisive now. We have the true common law and the true rights of use, which were beneficial, and that use then evolved into the trust, and that's what separates your common law legal estate from any damage. And that's the other beauty. At least when you're born, you're guaranteed that that is not going to be a lesser estate of lesser value when you're ready to vest it. Because it doesn't, everything that everybody's doing within and under government and under a trust for sale is a completely different subject matter, which is actually creating value. The more disturbances within that, the more value you're creating on the other end. I know it, you know, it doesn't sound good in the whole scheme of things, in the fact that, you know, you got to create waste in order for it to benefit to you. You know, that's not really how the thing was supposed to happen, but it just been chastised into this whole idea of creating more waste, thereby creating more legislation giving more power. And then we're getting less power by holding that equitable interest without understanding, of course, what the legal estate is and was. And that is, which has to be, as we know now, passed through your life. Because, as you know, most of you, and you can have that verified through your own Vital Statistics Acts and so forth, in the registry, they don't register the human. So how could they create rules over the life? They create rules over land. See? And that's why the registration of live birth, the one that the practitioner and your parents sign, which is more or less the indenture, is the proof of that agreement that's measured against an event. It's a witness of an event, not you know, putting down and having rights over the life itself, the infant, because that's as we can always revert to, is the fact that English law and any of its sciences and so forth cannot patent nature. What is already is already secured in what it is. You can't patent it. So therefore, they cannot patent or create anything or drive rules over that of nature. What they do is, of course, as we understand, they create land rights and then create, you know, if you want to hold that land right, create obligations, to which then those rights become patentable and everything. And that's why all of the science that we deal with is mainly pseudo-science, because they never deal with the principle. They never deal with nature. They deal with things they extract from nature, and then they create, and then that's how they make value in the system, is by creating it through those patents. You can't create any value in nature because you can't patent it. Wow. Okay, now my longest video, but I'm telling you what, I think this is a long-awaited video for many of you guys, and I hope you enjoyed it in the last two ones, and I'll see what comes out from there. But I'm telling you what, right this moment, if you didn't realize it before, you have all the power already. I don't need to even discuss anything anymore. You have it all. I mean, there is some subtleties, that there's devils in the details that maybe some of you are not connecting. It will. It took me a long time, and it you know, up until this day, that I really see the simplicity of it. Because again, divinity is simplicity. So you have everything right now. You don't need anything more, except for to assimilate and get your head around the fact that you can listen better of what all of these other people are talking about, and measurably, when you're speaking before justice, you know, a practitioner of the court, when you're listening, you can see when he's trying to see whether you get into another agreement. And if a lawyer's speaking, well, we already know he's void already, so that's gone. As soon as he speaks, it's void. Isn't that beautiful? The second that a lawyer speaks and introduces himself, it's already void, because you're speaking about your interest, and they're speaking about what's within their confinement, within their prohibitions and limitations. Okay, and you don't have those, as we've already alluded. And here I am just talking for the simple fact of talking, because I'm on a roll. And hey guys, have a good day. Again, I guess with the algorithms and all that kind of stuff, I don't know how that, you know, like and you know, share and subscribe if you haven't done so before. And by all means, any donation is greatly appreciated. And thank you guys for those who have donated this far. I really appreciate it. It's helped me even buy that book that I use here. It was $100-something that I had to buy. It helps a lot of things for me just before I settle my legal estate. Thank you guys, and have yourself a great day, and God bless.